Srikrishna submitting its recommendations on the data protection framework. It's called the Data Protection Bill of 2018, the draft bill, which has now been submitted to the government today. The 67-page report is overarching in its scope as it deals with how companies and the government should handle our personal data. It defines what qualifies as personal data. The report also calls for changes to many current laws, including the Aadhaar Act, the Right to Information Act, and the Information Technology Act. The report also deals with where and how companies should store our data. Before we get into specifics, let's listen into the Law and IT Minister Ravi Shankar Prasad and Justice Srikrishna, who spoke just a short while ago after the report was submitted.
Once the Supreme Court has given the judgment on privacy, we accord it the highest sanctity, and we would like India's data protection law to become some kind of a model for the global world also, which is a blend of security, safety, privacy, and innovation.
Well, we have talked about consent, when consent should be given, consent, whether consent is sufficient by itself, the circumstances when consent may not be possible, how to deal with such situations, consent insofar as children who are below the age of consent are concerned, how to protect their rights, and then the right of the citizen to have his consent recalled. A citizen will have a right of redressal. There is an elaborate mechanism set up for that. There is the data protection officer, there is the data protection authority, there is an adjudicating officer, there is an appellate tribunal, and finally the Supreme Court to hear appeals. All these have been enumerated in that.
Well, that's Justice Srikrishna on the report that has been submitted. Let's go across to cyber law advocate N.S. Napinai. Ms. Napinai, I appreciate you joining us here on CNBC TV 18. As I pointed out, we've been waiting for the details of this report, which has now been submitted to the government. Let me start by talking to you about the fact that Justice Srikrishna and the report clarifying that this is not going to be implemented retrospectively. In fact, the report says commonsensical that the law will not have retrospective application. It will not apply to any processing activity that has been completed prior to this law coming into effect. So a lot of questions on the Aadhaar data that has already been collected and whether the law would apply to that, that stands clarified now. If this were to be accepted by the government, there will be no retrospective application of the recommendations.
Yes, it appears so, Shireen. That's what the report seemed to indicate, but I'm still waiting to see the report in full before I comment on it. But assuming that that is the stand that the report takes, that it's not going to be retrospective. On one hand, it is true that logically one would assume that it cannot have retrospectivity because there are actions that have already been taken when this law did not exist. But having said that, in terms of protection, as a procedural aspect, in law, any substantive law will always have to be prospective. But procedural aspects can be given retrospectivity. So that is something that the draft can still be reviewed on. So it's still only at a draft stage, and there are still many more stages of review that it's going to go through.
Oh, absolutely. And we're still going over the 67-page report that has been submitted to the government just a short while ago. In fact, our colleague Ashmit Kumar, who has been tracking this and poring over the report, joins us now. Ashmit, before I go back to Ms. Napinai, take us through some of the other highlights that you've been able to gather from the report.
Well, what's interesting is that the report, the draft bill that has been submitted is quite severe when it comes to penalties. The first takeaway is that the penalty in case of non-sensitive personal data, the penalty is about 5 crores and 2% of the worldwide turnover. But in case of sensitive personal data, it can climb up to as high as 15 crores or 4% of the worldwide global turnover. Mind you, that is in line with the GDPR in Europe as well. In Europe, they do also have a penalty that is of the same amount, which is 4% of the global turnover. What's also interesting and what has also worried some of the stakeholders is the nature of the criminal offences as well. As of right now, there are the offences in the bill have been defined as a cognizable non-bailable offence. Mind you, under the IPC, rape and murder are cognizable and non-bailable offences. That, of course, is one side of the story. On the other side, as far as Aadhaar is concerned, this is the important takeaway here. While the recommendations does talk about certain amendments that are required, the draft bill is silent on that. The draft bill merely says that all entities will be required to be compliant with this data framework. So as of right now, there is still more clarity needed, perhaps more consultations, as the Law Minister was suggesting. That's another key takeaway. As far as enforcement is concerned, on the enforcement front, important to point out that there will be an overarching body. It will be called the Data Security Authority of India, and that will have a chairman along with 6 full-time members that will be responsible for enforcement. Other than this, another key aspect is that as far as data localization is concerned, again, Justice Srikrishna pointed out that there is a need to balance commerce along with the need for securing data. And on that count, he even criticized the RBI for perhaps jumping the gun. But the broad approach appears to be that the sectoral heads, sectoral regulators will be the ones for implementing the nitty-gritties and formulating nitty-gritties of the policies with respect to data protection. So towards that end, there is some leeway, some discretion provided to the sector regulators. And finally, on the issue of as far as compliance is concerned, again, there are very strict provisions, and the bill is very, very clear that there will be that all entities, government or private, shall have to comply. We'll, of course, have to go through the recommendations and see what is the nature of amendments they have suggested to the Aadhaar, but not a part of the bill.
All right, Ashmit, I will let you go back and pore over the 67-page report submitted, but let's go back across now to Ms. Napinai. Ms. Napinai, let's pick up on some of those recommendations that Ashmit was pointing out, and let me start by asking you about the penalty. In case of violation with respect to sensitive personal data, the fiduciary shall be liable to face 15 crore rupees or 4% of worldwide turnover, whichever is higher. In case of non-sensitive personal data, the liability will be a penalty of 5 crore rupees or 2% of worldwide turnover, whichever is higher. Your first thoughts on the recommendation when it comes to the penalty?
One, it's in line with the GDPR, as Ashmit rightly pointed out. So to that extent, it's good. It's a good thing that we also are taking our data very seriously. And two, in fact, this is also in line with the draft report that the Srikrishna Committee had circulated earlier, where they said that the penalty has to be commensurate and sufficient enough to be a deterrent for violation. So to that extent, at least they've given it as a layered process, and hopefully such a stringent provision will be good. Having said that, the concern from the industry is that there are a lot of startups in India, and that they may not be able to comply with this. You know, I mean, like, this may be a killer for them. I mean, like, that is something they'll have to figure out.
And also the fact that an offence... Sure, and also the fact that an offence under this Act will be cognizable and non-bailable.
Well, on that count, let me tell you, the Information Technology Act already has some data protection provisions. And yes, they do. I mean, like, the reason why probably Ashmit pointed out is that these carry much, much lower penalties. And therefore, you know, when you look at it as a paradigm jump in terms of how much more serious they are making it, it may seem like it's being too punitive. But having said that...
Okay. Might be seen as too punitive, but let's once again, for the benefit of our viewers, just go over some of the details that have come in from the Justice Srikrishna panel when it comes to the right to be forgotten, the right to confirmation, access and correction. This is a long, elaborate framework that has been submitted to the government today, and what is going to be important, as Ashmit was pointing out, when it comes to the issue of data localization, which really has become a very controversial issue, with the US raising it and speaking out against it. And now the Srikrishna Committee report also seems to suggest that the Reserve Bank may have, in fact, jumped the gun. Well, we'll keep going over the recommendations and bringing you highlights here on CNBC TV 18. But for now, we'll take a break, and there's a lot more coming up, Arib.
Right, Shireen. Many thanks for taking us through that conversation.